epidemic of harms to children, and particularly we're focused on this rampant level of child sexual abuse material. We have child pornography rampantly on the internet. We have children being groomed and extorted and sex trafficked over the internet. And there is no way to hold accountable websites, even when they are actively facilitating this bad behavior or knowingly profiting from it.
Honestly, when people hear about it, it's a forehead slap moment. Like, seriously, why is there absolutely no pressure on big tech to protect the vulnerable on their platforms?
Now we're dealing with basically an industry that has little to no regulation. So there's no agency, government regulation over this industry, and users cannot sue this industry for virtually anything. Sexual exploitation and sex trafficking was exploding online. We dug into why is that? There's actually this federal law that insulates them from any liability.
A number of years ago, when the internet was kind of getting its first set of regulations, Section 230 of the Communications Decency Act essentially ended up giving an absolute free ride to big tech, that they have no culpability for what happens on their platform.
Section 230, quite ironically, was a child protection bill. So in 1996, at the beginning of the internet, Congress was already concerned about children. Their constituents were coming to them saying, our kids are being contacted in chat rooms, they're being exposed to harmful content. And so Congress was acting there right then at the beginning of the internet to protect children. But the tech industry and their lobbyists were raising an alarm because there was a court case that had come out of New York recently that had a ruling they found problematic. A court found that a website was liable for defamation because they had moderated. So they effectively lobbied Congress that if websites are going to be responsible for everything that anyone posts, that's going to really squash innovation. That's going to crush this new industry. People are not going to have the money or resources to even start, or they're going to be deterred from doing so because this threat of liability is so large. So from that sort of place, Congress brought in Section 230 as a compromise, which said that, okay, websites are not going to be put in the shoes of publishers for third-party content. But unfortunately, every child protection provision was struck down at the Supreme Court as unconstitutional, and all that remained was Section 230. So now you have a child protection bill, which purpose was to protect children, with a compromise to insulate a new tech industry from some liability, being reversed into now this is a tech protection bill. Section 230 is viewed as an ironclad protection for websites.
Section 230 is how these companies have gotten big, it's how they've gotten powerful, it's how they've gotten rich.
Section 230 is the most important law protecting internet speech. And removing Section 230 will remove speech from the internet.
Section 230.
Section 230 status.
Section 230.
Section 230.
Section 230.
Section 230.
Over the 20 years since Section 230 was passed, court cases take it a step further and interpret that as broad immunity, not only from liability, from even the ability to sue tech companies for virtually anything that happens on their websites. So that's way broader implications than Congress ever could have anticipated. Also in 1996, Congress never could have predicted how large the internet would be or the different uses that these websites or applications. They never could have fathomed that we would be walking around with essentially the entire web in our pocket. Because they have such broad protection, it was creating an atmosphere where these tech companies had no incentive to make their platforms safe or to protect children if it would cost engagement and therefore cost dollars. And we realized that that legal regime was really the problem.
Facebook is profiting off and amplifying disinformation that harms others because it's profitable. This isn't a speech issue.
We set out to reform Section 230 either through litigation in the courts or at Congress.
We're familiar with the car industry, has a continuous flow of recalls where, hey, if they make something that's not safe, they have to both pay people if they cause damage to their lives, and they have to fix those products. We can have incredible capitalism and put some form of mechanisms akin to the recall structures within the automotive industry, but it doesn't exist today.
We've brought several cases that would address this. And one right now we have against Twitter, where we represent two minor boys who were sextorted on Snapchat. The result was that child sexual abuse images were created, and then they were 16 and in high school when a compilation of these horrible abuse images were circulating all over Twitter. Their entire high school knew. One of our young clients was suicidal because of this. The Ninth Circuit said that Twitter's involvement in the sex trafficking of this child, that even if they knew it was child pornography, that Section 230 immunizes the knowing possession of child pornography. We think that's just dead wrong. And so we're preparing to file a petition to the Supreme Court because this is a very easy equation for the Supreme Court to weigh in on the scope of 230. Does Section 230 truly immunize a platform for its own knowing possession and distribution of child pornography? If we can get court-ordered procedures on how they have to conduct their business moving forward, that could have ripple effects across the industry.
It is clear that Section 230 in its current form is no longer working.
This law needs to be updated so that it continues to work well.
I think that Congress should update the law to make sure that it's working as intended.
I have a lot of hope that we're finally reaching the point where change can happen.
These stories are building. Momentum appears to be clearly building for some form of changing CDA 230. It feels like every few days right now, we see some sort of headline that indicates there's a lot of demand from parents that their children are protected on these platforms. There's demand from the judiciary system. There is rumblings on Capitol Hill. It does look like all momentum is towards actually some form of safety coming to big tech.
There is now hundreds of thousands of parents and grandparents whose children and grandchildren have been affected. So there is an overswell of public sentiment and sentiment at Congress that something needs to change. There's now been whistleblowers, there's been unbelievable news reporting on the lies that big tech has told us. And so we're reaching a point where collectively society is understanding the problem, we're now understanding the solution, and that, at least in part, that is this immunity needs to be reformed. So I think the time is now, and just the right case either needs to come to the Supreme Court, or we need congressional reform, or maybe it's a little bit of both. But I think both the public sentiment, the grassroots efforts, the unbelievable survivors, the children, the trafficking survivors, abuse survivors, the parents that are coming forward, we're really reaching just a zeitgeist moment where everyone is sort of coming to the same conclusion except tech. And so as large and powerful as they are, they can't beat back that wave.